Hey out there, legal warriors. This video took a lot of time for me to develop the knowledge to share here. This video is going to be about advanced strategies if you have a restraining order served on you in Washington State. These are things that I've learned over many years that's going to help you get the result that you want and you deserve. That's interesting to you? Stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and we also do restraining orders. Basically, criminal attorneys and family law attorneys are the main type of attorneys that do restraining orders because they're like high-pressure little mini trials that happen in a snap. And so it's pretty stressful if you get served with an order. Why I'm doing these videos is to help educate the public. So if you find this useful, like and subscribe. Now I'm just going to jump right into it. What are the advanced strategies you're talking about, Lance? Well, first, let's back up and start. What do I mean by a restraining order? Restraining order is where one human, not the government, a person goes out there and says, Judge, I'm going to use RCW 7.105, the disaster of a new law that's been around for about a year that is terrible against respondents. It makes me sick at night. And in the day when I look at it, that says, hey, it's very easy for anybody to go get a temporary restraining order against another person. The petitioner asks for an order, writes a petition and says the reasons why they deserve an order, and ex parte, that means one-sided without any notice to the respondent, goes into a court and the court goes, oh, that respondent sounds terrible. Here's your temporary protection order restricting the freedoms and rights of the respondent. And the legislature was so brilliant, they made it so they didn't even consider the opportunity that people would lie, that people would not tell the truth. They had some idea that I guess the court would just hold the line when they made it so broad that garlic breath is enough for an order, in my opinion. We need advanced strategies if we're going to try to defend ourselves against a restraining order if we're the respondent. So when we get served with that order, we look at the order and it says, hey, I'm restrained and there's a court date and time. What do I do? I don't even know what to do. What you're supposed to do is you're supposed to read the petition and then go ahead and file a response in writing to the matter. And I've got other videos that talk in more detail about that. So I'm not going to go into what you do there. Search out my other videos because this video will be half an hour long and no one wants to watch a half an hour video. But you're supposed to file a response and then you go to a hearing where the judge will hear both sides and then they're going to grant an order against you most of the time. I mean, almost every time. Okay. Unless you hopefully take care of some advanced strategies. So what's the biggest advanced strategy that we even just use successfully in a case? Well, think about it. When you get, I just told you the petitioner has this huge advantage, right? And the way the law is defined is very broad. They might have the burden of proof, but we're only proving garlic breath, remember? So wouldn't it be great if we could also be a petitioner? That's what I want you to think about. Has the petitioner done something to you where you can file your own request for an order in the same court or even a different court, because you're just as entitled as they are to petition for an order. So if they've threatened you, if they've pushed you, if they've harassed you, if they've stalked you, what have they done that you can look up under the statute and all the helpful things about restraining orders? Now online they're called protection orders. Okay, Washington calls them for protection order. I use the word restraining order because that's what people search on, and you're not going to find my video otherwise, right? And that's what people call it. But so in Washington State, they're called protection orders legally, but I'm referring to them as restraining orders. Is there something that petitioner's done to you where you can go get your own order? Now, it's not always the right idea. You need to talk to an attorney, and feel free to call my office, although we get dozens of calls in this a week. So I can't guarantee I can talk to you, but many lucky people are able to talk to us. You could go file your own request for an order, and now you're on equal footing, right? Eventually, there might be multiple hearings, but probably eventually these cases are going to get on the same calendar. And now each side sort of gets the benefit of being a petitioner. Now you've taken away all that disadvantage of being the respondent. So not everyone can do that. It's not so easy to do. It's a lot of work, but we did that in the case recently, and we were so successful that all the cases ended up getting dropped, and my client was no longer a respondent and had no order against him or her. Okay, so it does work. It has worked, not in every case, but that is an advanced strategy. What's another advanced strategy? Well, I think a really advanced strategy is trying to tell your story, if you're just having to do a general response, in a way that makes it so easy for the reader, the judge, to see your point of view. You've got to really uh, rely on good writing that explains. Write out your paragraphs, right? And then go back and look at the paragraph and ask yourself, what am I trying to say here? Well, if I'm trying to say the petitioner is not afraid of me, you've listed all this stuff, but you haven't said that. Start the paragraph with, the petitioner is not afraid of me. Then list all the examples of why that is, right? Well, they stayed with me for 3 weeks after the event. They came to my house and asked to borrow a cup of sugar if it's a neighbor. Who knows what? But you've got to make it so the judge doesn't have to struggle to get your point, because they won't do it, right? They've got 15 cases on the calendar. They might be 25 pages each. Do you think they actually want to struggle to get your point? They won't, right? It's already rigged against you. You're the respondent. You've got to make the writing beautiful. Maybe you can use ChatGPT to help you, right? Everyone else is using that for everything, right? But or if you get a good law firm to help you, my law firm has a writer. I have a writer that just writes these. That's that person's job. And then I help edit it and all that, and so do other people. But it is hard to do. But a secret weapon is having your writing be understandable and clear and easy to digest. The same way with exhibits, right? Label what the exhibit is. Make it clear so any 5-year-old can tell what you're trying to say. Then you have a chance. Okay, you have a chance, because once the judge struggles to understand your point, you're done. It's over. You're through. Okay, so that's a secret weapon that you can use. It's an advanced strategy. It's something that you need to do. Now, the third advanced strategy is timing. Okay, you need to give the court enough time to actually have read your materials. You can't walk in with your response the day of and go, here's my response, judge. They won't read it. They don't have time. There were 15 cases or more, right? And they're going to be really mad at you. And what if you filed it the day before? They didn't read it. It probably never made it to the file. You understand how overwhelmed the system is. Remember what I told you? I told you that anybody gets an order for anything now. There's zillion orders out there, right? That's all there is. Of course, doing orders, right? So you've got to get it filed in time so they can actually read it. Remember, we actually have to serve the other side too. What's filed in time? Well, some courts have rules. We try to think at least 3 days ahead of time is what I think, right? 3 court days ahead of time. There's some chance it gets in the file and the judge came in early and the judge actually read the thing, and hopefully it's written so they can understand it. So that advanced strategy, get it in on time, get it in early enough. Now, if you get it in too early, and then you give the other side more time to come up with stuff to crush you, right? So it's a balancing act, right? The strategies are advanced for a reason, but I want you to think about how you can get it there in a way that it's easy to be read and is likely to be read because they got it soon enough. Okay, so those are some advanced strategies. Feel free to check out my other videos on the channel for more details. Even though a lot of my other videos might have been under the prior law, it's still the same idea how we do responses. The current law, which took into effect July of 22, is a law that's so anti-respondent. I can't wait till members of the legislature have to deal with this personally, and then they might understand the mistakes they've made, in my opinion. And when I represent petitioners, I love it. I love the law. When I represent respondents, I hate the law. And in general, I think it is so subject to abuse, and it's so traumatic for people, the situation, that I think it shouldn't be quite as broad. I want people to be protected. I understand why the legislature did it, but in my opinion, they've overdone it. So if you're a respondent, get yourself an attorney, or Maybe we'll tell you shouldn't get one if it looks hopeless, if we don't want you to waste your money. But, and use these advanced strategies to whatever degree you find helpful to try to improve your situation. So if you found this useful, please like and please subscribe. More people get the help they need. And more importantly, if you've got a restraining order, a protection order in Washington State, feel free to reach out to my firm. We're always changing how we do it. It's always different things that we do. But if we're able to get you in, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.